Before his ascent to the Supreme Court, Justice Neil Gorsuch was well known in legal circles as a keen mind, pithy writer, and vigorous defender of fake belching. As a judge on the 10th U.S. Circuit Court of Appeals, Gorsuch wrote one of his few dissents in a 2015 case involving a middle school student who was arrested for making fake burping noises during gym class. In a 2-1 decision, the 10th Circuit ruled that the student's mother could not bring a suit against the police officer who executed the arrest. She is now asking the Supreme Court to take the case, and the justices could announce a decision on her petition as soon as Monday. The incident occurred in New Mexico in 2011, when the unnamed student incited disorder among fellow students by unleashing a torrent of fake belches. Unable to regain control of the class, the gym teacher asked school officials to intervene and help re-establish order. A police officer came to the gym, handcuffed the student, and took him to a juvenile detention facility where he remained for several hours. Though disturbed by the facts of the case, the 10th Circuit ruled the officer was entitled to qualified immunity, which generally protects police from civil suits when they are acting in their official capacity. The student's mother argues the officer's behavior is not protected because the arrest was unconstitutional and because an earlier New Mexico Court of Appeals decision notified the officer that arresting students for such behavior was unlawful. A case about school discipline might be heading to the Supreme Court, but the court's newest justice would likely recuse himself from the case. Neil Gorsuch wrote a cutting dissent when the case came before his appellate court, and his words are now being used by the plaintiff's lawyer. In 2011, a 7th grader, known as FM in court documents, was interrupting his gym class with fake burps. The antics were amusing his classmates, and his teacher was struggling to maintain control of the class. She called for backup, in the form of a police officer assigned to the school. Officer Arthur Acosta arrived on the scene, and asked FM to come with him. The boy complied. Then Officer Acosta informed FM that he would be arresting him for the disruptions. FM was handcuffed and taken to a juvenile detention center, where he spent about an hour. He also received a 1-day suspension from school following the incident. FM's mother, referred to in court documents as AM, filed a lawsuit against 2 school officials and the police officer, alleging that her son's civil rights were violated by the arrest and the use of handcuffs. The complaint said that the defendants should have known that burping was not a crime and that no force was necessary in assisting with the arrest. The 10th Circuit U.S. Court of Appeals upheld a decision from the lower court in support of the school officials and the officer. But, Neil Gorsuch, who was on the federal appeals court at the time, wrote a spirited dissent. It concluded, "Often enough the law can be ass, idiot." Charles Dickens, Oliver Twist 520, Dodd, Mead and Company 1941, 1838, and there is little we judges can do about it, for it is, or should be, emphatically our job to apply, not rewrite, the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge, reaching for results he prefers rather than those the law compels. So it is I admire my colleagues today, for no doubt they reach a result they dislike but believe the law demands, and in that I see the best of our profession and much to admire. It's only that, in this particular case, I don't believe the law happens to be quite as much of ass as they do. I respectfully dissent. Now, the boy's mother is again appealing, this time, to the Supreme Court. According to reporting from the Associated Press, the court could decide as early as Monday whether to take up the case.